or I'm the third or fourth car. And then I go in and provide the testimony that's necessary to get a conviction. In terms of his concerns when he made these statements, bear in mind, this is the Detective Ferman who says to Miss McKinney when she asks, well, can we use this in the screenplay? No. Hasn't been 7 years yet. Statute of limitations. If that doesn't show a consciousness by the speaker of potential criminal liability, I don't know what does. But alternatively, regardless of whether there's a potential fear of criminal prosecution or simply a fear of social ostracism, the result is the same under Section 1230. These are declarations against interest. They are highly probative declarations against interest, and we believe that the unavailability of Detective Ferman should render those statements admissible.
Thank you, Counsel. All right, the record in this case indicates in our hearing yesterday outside the presence of the jury, and that was an appropriate procedure to proceed outside the presence of the jury because the counsel for Mr. Ferman, Darrell Munger, did advise the court that it was and counsel that it was a possibility, in fact, a likelihood that Mr. Ferman would, in fact, seek to exercise his right not to testify under the Fifth Amendment to the United States Constitution. After we held our hearing yesterday afternoon, the record is also clear that Mr. Ferman will refuse to answer any further questions as a witness in this case, and he is therefore unavailable within the definition of Evidence Code Section 240. The record is equally clear that when we adjourned, that the cross-examination as to Detective Ferman was adjourned subject to recall for further cross-examination. The subject matter that Mr. Ferman is likely and reasonably and appropriately subject to further cross-examination, we have heard over the last day and a half 4 witnesses who have come in to testify for the specific reason to impeach the testimony of Detective Ferman. Kathleen Bell was called, and this is not a particularly compelling reason for further cross-examination since Detective Ferman was in fact asked questions about Ms. Bell on direct examination and cross-examination, and there was sufficient opportunity since counsel on both sides were aware of the facts and circumstances that led to Ms. Bell coming to the attention of counsel on both sides. However, as to Ms. Singer, as to Mr. Hodge, and as to Ms. McKinney, Detective Ferman was not direct or cross-examined as to any of the statements made by those 3 witnesses who were called for the specific purpose of impeaching Detective Ferman. The prejudice to the defendant based upon this unique set of circumstances is the inability to further cross-examine as to these 3 witnesses and the impeachment evidence that they have offered through their testimony, that is Singer, Hodge, and McKinney. However, the case law is equally clear to the court that it is not appropriate to call a witness before a jury that counsel know will invoke the privilege, and that is clearly the fact and circumstance here. And the court will therefore deny the request to recall Detective Ferman at this time in front of the jury. The instruction offered as an alternative by the defense, which has been already read into the record and which is page 3 of the defendant's points and authorities, does have the disability of mentioning the invocation of the right against self-incrimination. Evidence Code Section 913 clearly states that it is not appropriate to comment upon or bring to the finder of fact's attention the invocation of a privilege. California Jury Instruction 2.25, CalJIC 2.25, deals with the situation where a witness, in the course of testifying before the jury, invokes the privilege, and then the jury is then instructed not to infer or imply anything from that invocation. Therefore, the court will instruct the jury as follows. Detective Mark Ferman is not available for further testimony as a witness in this case. His unavailability for further testimony both on cross-examination is a factor which you may consider in evaluating his credibility as a witness. Now, having found that Detective Ferman is unavailable as a witness under Evidence Code Section 240, the court then has re-examined its ruling with regards to the 5 excerpts which are now offered as statements against penal interest. And the court, having evaluated those, finds that the court's previous ruling was appropriate and the objections will be sustained. All right. You ready to proceed?
Then we have a moment, John, we need to discuss.
No, I'm not to address the court. We feel that the proposed instruction that the court is going to give to this jury will cause the jury to speculate on the reason for his unavailability.
Counsel, I've ruled. That's a final ruling. Thank you. Scheduling.
Maybe we have just a couple minutes to talk about a couple things we make. I think the court knows who we are at this point, so I'll just take it.
All right. And I'm likely to instruct the prosecution to be ready to start with their rebuttal witnesses tomorrow morning. And we'll take up the issue of admissibility of the exhibits probably later today.
We will move for reconsideration tomorrow morning.
Well, I'm going to instruct them. I'm going to instruct them this afternoon.
And when you say just finish,
All right.
John, we'll be ready. We'll let you give,
All right.
let Ms. Robertson know in just a second.
10 minutes.
Oh, thank you very kindly. 2 o'clock, we'll be ready. Okay.
All right, back on the record in the Simpson matter. All parties are again present. Ms. Clark.
Yes, Your Honor. We are preparing an emergency stay at this time. I request from the court a written ruling indicating the basis for its ruling concerning the jury instruction proposed.
All right, that request is denied.
Case authority that supports the giving of the instruction that the court has proposed.
All right. I'll prepare have the clerk and the court reporter prepare a transcript of the proceedings and the arguments today. That'll be your record.
Okay, and the case authority that the court has relied upon for this, for the instruction? Emergency stay at this time. We would request until tomorrow morning before the court consider instructing the jury on this matter. We do need the time to prepare the paperwork in order to submit it to the Court of Appeals. If I may remind the court has previously given the defense time to submit appeals. And
I don't know that I've given them time, but I've encouraged them to do so.
In any event, the court has previously given the defense time to prepare their appellate papers in order to file them, and I'm asking leave of the court to give the people the same opportunity.
Till 9 o'clock tomorrow morning?
I will consult with appellate. I think that at least that long would be required. I would also urge the court to consider the fact that an immediate instruction to the jury is not necessary. The jury will be given a number of instructions at the end of this case, and that will be ample time to give that one if it is deemed appropriate by the court at that time. So it's not like this is something that needs to be done at this very moment.
All right. Mr. Cochran?
We'd like, the court has already ruled. You've indicated you've ruled. The jury's here. They've been sitting on their hands since 10 o'clock this morning. We want to proceed on. We want to get to a point where we can effectively rest. Ms. Clark misstates. What the court said to me last Thursday was, Mr. Cochran, you know where the Court of Appeals is right down the street, if you want to do that. And
Right down the street, a block and a half.
a block and a half. Well, you have total recall. You invited me that, and you didn't give us any time to do anything. You just told me where the Court of Appeals was.
You didn't ask for any.
And I didn't know. I didn't ask, but she said you gave us time. You didn't give us any time. We didn't ask for that. Your Honor, we have to bring to conclusion. They knew this day was coming. Everybody knew that. It's not going to save them till tomorrow morning. What you're doing is minimally, entirely appropriate. We want to move on with this case, Judge. We have a jury that's going to be mutinying. very shortly, as this court knows, and we need to resolve this matter. We saw them walk through here. They want their distress. They should be able to hear something, find out, as we talked about this morning, this case will be over within the next 7 or 8 days, given rebuttal and surrebuttal on both sides. And I think that's at least some good news for these folks, and they have a right to that. And we want to resolve this matter. No reason to wait until 9 o'clock tomorrow morning. It's not going to change anything. If they want to bring a writ, they can bring a writ, but it's not going to stop anything. You are not abusing your discretion in this regard. And we want to proceed. You've ruled. You told them you'd ruled, and let's go on with it.
All right. Thank you, counsel. Ms. Clark, Mr. Cochran, as Dean Uelmen mentioned, this is a unique factual and legal situation, something that I've never seen before, never had to contemplate before. Of course, that's nothing unusual in this particular case. I'll give the prosecution till noon tomorrow. Let's stay on that. And we will have final instructions, my guess is in the next 10 days to 2 weeks. But giving a stay might cause me to modify the instruction to say that at the close of the presentation of the defense case, Detective Mark Ferman was not available, etc., so that the point in time is set in the instruction. All right. Mr. Cochran, anything else?
Well, that's put us in a position. We can't rest until, I guess, till noon tomorrow, so that effectively what they've done is wasted the rest of the day and half a day tomorrow. We can't really do anything, can we, based upon this? And nothing's going to come of this, Your Honor. This is a matter of your discretion. We argued the law, and I can understand Your Honor being patient, but I just think that you ought to reconsider this, because we do have the whim of this one prosecutor here. We have these 14 jurors back there. So what if we lose all of them by virtue of this is going to be a wasted action? And tomorrow at noon you'll do the same. We'll do what you're going to do right now. We will have lost all that time. Right before the break, Your Honor indicated be prepared for rebuttal tomorrow. It means we'd cut off one more day, or at least a half day. So that's all I'm saying, is I'd urge the court to reconsider that. We're going to be in exactly the same position, Judge, it seems to me.
Well, Mr. Cochran, really, at this point, given the unique situation, factual and legal situation presented by the Ferman situation, I doubt that a court of appeal, frankly, is going to intervene on an interim jury instruction. I would be surprised if they did.
I would too.
And especially in light of the nature of the instruction. Given that fact, I think it would help us all if you rested at this point, subject to asking to reopen if an issue is presented by the by the Court of Appeal of the jury instruction. But I don't know what other witnesses you would call, even if the instruction changed significantly or was withdrawn.
Well, if I can have a moment, I might consider that. I might consider doing that, Your
The
Honor.
reason I say that is we've got the jury. If they knew that you were resting today and that the prosecution could move forward with their rebuttal case tomorrow morning with the witnesses that they have planned, and that we will spend the remainder of today going over the evidence that the defense is going to offer and resolving those disputes. Tomorrow at 2 o'clock we have motions on calendar for public agency access to the Ferman tapes. We can conclude, hopefully, the evidence issues after we conclude that hearing. And we can move along with unhesitatingly into the conclusion of the rebuttal case next week.
The only problem with that, Your Honor, and certainly we want to cooperate with the court, but we're doing all the giving. We're doing the resting. We're on track to resolve this. And they're standing over there being petulant, saying we want to wait till tomorrow. And so I'm saying that I want to be reasonable. I'd like a moment to confer with my colleagues. But I mean, I think that...
Well, I'm just suggesting to you that even if the Court of Appeal were to intervene, would you call any additional witnesses in light of that, given the court's other rulings, etc.?
I don't know, Your Honor. Perhaps we might, if they insist on this, we might join on the writ and ask the court to allow us to play the rest of those tapes. You know, be careful what you ask for. You've said that many times, right?
And I'll say it again.
Be careful what you ask for, right? May I have a couple minutes, Your Honor?
Certainly.
May I ask that the court has been very clear that it does not appreciate personal attacks. Mr. Cochran stands before this court daily and engages in that very thing at sidebar and before the court, saying that the jury is being made to sit at my whim. It's not a whim when the people feel that there's been a violation of law that may seriously impact on the people's right to a fair trial. That's no whim. That's serious. And I am the advocate for the people. It is my duty to make sure that when I think a violation of law has occurred to the detriment of the people, or the defendant for that matter, it is my duty to do all that I can to make sure that that is remedied.
Thank you.
That's no whim, Your Honor.
Thank you.
And I'm not being petulant in insisting on enforcing those rights. Nor did I ever accuse the defense of being petulant when they asked for time to prepare a writ to reinstate a juror, which the court generously gave them, and to which we did not object.
Thank you.
I have what I hope is a reasonable proposal, Your Honor. We'd like to do everything that you've asked with regard to, there's a stipulation on Matheson, there's the argument regarding the evidence, and any of those things you want to do. We want to do everything with the exception of resting until such time as this matter is resolved, because we think the natural and logical thing is to give that jury instruction at that point. So everything else we can do, and we'd ask leave the court to do it that way.
It's very coherent, doesn't satisfy my needs today.
As we do everything you ask, Your Honor, except we will rest, you know, at that time, if it's noon tomorrow or 11:59 or so, and then ask you to read the instruction at that point. I think we don't lose anything by that, Your Honor. And you've already told the jurors that we're at that point. But I think that just from the standpoint of discussing with my colleagues and my client, we just don't feel that it would be appropriate for us to rest at this point, Your Honor. But we'll do everything else. We'll be available as late as you want or as early as you want tomorrow. One reason why and I'm sure you appreciate this, the next logical thing, as you've said so many times, this is a smart jury. The next logical thing, based upon the evidence we presented over the last 2 days, is that, and they know Mark Ferman was never excused because in their presence you said that he was on 72 hours call, is it doesn't take a rocket scientist to know that would be the next logical witness. And so we think it inures to Mr. Simpson's detriment to talk about resting at this point, and we want to rest at the point when the instruction is read. I think that explains it, it makes sense, and that's why we made that decision, Your Honor. But other than that, we're ready to proceed with everything you want, as late as you want to stay today, and tomorrow, and all the other issues. So we don't really lose anything.
Problem is, then we can't start with then why don't we reschedule the argument on access to the tapes at 9 o'clock, and we'll start the rebuttal case tomorrow at 2 o'clock.
That's
Go to
fine with us,
5.
sir. No, we're fine. We're fine with that.
All right.
No,
we
we're
have-
not.
Why?
The court represented to us at sidebar this morning that we would not begin rebuttal until Monday. I went up and instructed everyone to have the witnesses stand by for Monday. And I don't know that we can get someone in now at this short notice.
Have them here Monday, have them here tomorrow at 2 o'clock. 2 o'clock.
I cannot represent that we can, based on the court's earlier representations to us.
Well, then you'll rest. Have them here at 2 o'clock.
Is the court now going to penalize the people because the people are exercising their appellate rights as they're entitled to do? It would appear that you are.
I'll see counsel in chambers. Back on the record in the Simpson matter. All parties are present. Jury is not present. Deputy McNair, let's have the jurors, please. All right, let the record reflect that we've been rejoined by all the members of our jury panel. Good afternoon, ladies and gentlemen. Well, at least 2 of you are smiling. 3. All right, ladies and gentlemen, good news, bad news. The good news is that the defense has told me that they do not anticipate presenting any further witnesses. And if you recollect, when we concluded the prosecution's case, I had to take about a day to go through the evidence, all of the exhibits that had been presented to me. And as you know, there have been several hundred exhibits that have been offered by the defense so far, and I have to go over each one of those pieces of evidence to determine whether or not they should be submitted to you for your deliberations when the time is appropriate. So the good news is that we will be concluding, I anticipate, the defense case by tomorrow. Is that correct, with no further witnesses, Mr. Cochran?
Well, I would anticipate that's perhaps correct, Your Honor.
All right. I've also instructed the prosecution to be prepared to present their first rebuttal witness Monday morning. And Ms. Clark, you anticipate being able to present your rebuttal starting on Monday morning, correct?
Yes, indeed.
All right. My understanding is that the rebuttal case is presently estimated to be 5 days by the prosecution, and then perhaps 2 days of sur-rebuttal by the defense. Is that an accurate assessment, Mr. Cochran?
I believe so, as regard to the server.
All right, Ms. Clark, excuse me, Ms. Clark.
We're not related yet?
Yeah.
I think that's good.
All right. So the good news is that the end is in sight. The bad news is I got a lot of work that I have to do out of your presence, and I apologize for keeping you on hold today. Some significant, and I have to tell you, issues came up that I had never had to deal with before. I had to do a lot of research on the issue, and one of the issues is not yet resolved. So I still have to work on it. I want you to know that we will be in session for the remainder of today, going over the items of evidence with the lawyers. Tomorrow morning, I anticipate we'll have to spend concluding that. And tomorrow afternoon, I have another hearing set at 2 o'clock as to a completely different issue that involves this case. So we're working hard. But I want you to know that the bailiffs do tell me that you're not happy campers again. and I appreciate that. And my biggest concerns when I discuss these matters with the lawyers are your feelings and the inconvenience to you. But that's the bad news, is that I don't have anything further to present to you today or tomorrow morning in all likelihood. We have activities planned for you tomorrow afternoon. There are also some doctors and dentist appointments that we need to take care of with you all, so we're not available to do anything tomorrow afternoon. So at this point, unless I hear from you further, I'm going to wish you a good weekend, but you should know that we'll be here working a full day tomorrow, Friday. Please remember all my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case. Allow anybody to communicate with you with regard to the case. And have a nice weekend. All right, thanks for the couple of smiles there. All right, as far as the jury is concerned, we'll stand in recess until, I'll put them on call for tomorrow morning, but we'll stand in recess in all likelihood till Monday morning, 9 o'clock. All right, we'll take a recess to clear the jury, and then I'll see counsel with regards to the evidence. Both sides have their lists? All right, let's take 10.